Okay, it's 11 o'clock. Time to start up again, guys. So let's get busy. We're going right into Unit 6, Chapter 6, Estates and Interests. So I'm moderating the conversation as I start presenting. Now, our conversation on this chapter has to do with ownership interests of real estate. Let's just take it as it progresses. At the end of this chapter, you should be able to identify the characteristics of different estates in land, as well as describe the characteristics of encumbrances, such as liens, easements, and encroachments, and there are others. So let's talk about estates in land or ownership rights in land. Today, we're going to talk about a freehold interest in real property. Freehold interest infers an ownership interest in real property. The other type of estate in land is called a leasehold estate, also known as a less than freehold estate. And on Monday, when we talk about landlords, tenants, and their relationships and leases, we're going to talk about the leasehold estate. But today, we're going to talk about freehold estates that are recognized here in New Jersey. So Dana, you have a question. So what's the question? Let me open it up for you. Dana Richter, what's your question? Or is it Dawa? Dara. I'm sorry, I can't read that small print from this far away. Dara Richter, yes. What's your question, Dara? Dara? Hello? Oh, gee. Please don't tell me you left your conversation tab open and we're delayed for this. Did you walk away and you're not even here with us right now? Guys, this is not really acceptable. Please stop doing this. It was me. I disappeared for a minute. I'm back. Don't worry. So I'm going to moderate. And I'm sorry, I'm just going to have to refuse all requests for questions until I'm ready to break. So guys, please be a little more conscientious of this. So we're talking about freehold estate interests in real property, ownership of property. There are three types of freehold estates. The first one is called a fee simple estate. Oops, I'm sorry. The leasehold estates, which we're going to talk about Monday, involve tenants and landlords and are classified as personal property. Sorry. The freehold estates, fee simple, fee determinable, and life estates. That's where we're at. So the first one, a fee simple estate, is a freehold estate, meaning you own property. And a fee simple estate is the highest recognized ownership interest recognized by law in New Jersey. So when you buy property as a fee simple ownership, you own property to the highest degree recognized by law. Most people, when they do buy real estate, achieve fee simple real estate. However, there's other types of ownership, which we're going to talk about in a minute. First of all, fee simple, you're entitled to all rights in the property that are afforded to you by law. And upon your death, your estate could pass to your heirs, if you wish. A fee simple estate is known as a fee simple absolute estate. They're all interchangeable terms. It's the highest recognized ownership interest in property, and you're entitled to all rights that are afforded a property owner. Fee simple estate. However, not all property is fee simple. Some people may receive fee determinable interests in real property. What's that? Well, it's not the highest recognized ownership interest in real property in New Jersey. It's actually less than full, complete, undeniable ownership rights of property. It is a situation where someone owns property that their rights of ownership could be terminated based on an occurrence or non-occurrence of a specific event. What? In other words, it is a conditional ownership interest of real property. So let's propose a scenario. I'm selling my house, and in my deed, I put a condition of ownership into any and all future owners. That the house must be painted safety orange forever. Whoever buys the house in the future must keep it painted safety orange. Well, have you ever seen safety orange in the sunrise or sunset? It's kind of blinding. But if you want to buy my house, you have to keep it painted that color. So if you want to buy my house, then you would buy it, but you could never change the color of the house. It must be always safety orange. And what I would do is I build into the deed of conveyance that this condition must be honored. If you don't, then the property automatically reverts back to me or my estate holders. What? Yeah, so if I sell my house to you and you change the color of it, well, as soon as you change the color of the house, you lose ownership rights of the property, and that property reverts back to my estate with no cost, or my heirs, whoever succeeds me, if I'm not alive. Whoa, what? Yeah, I'm being very serious here. A fee determinable interest means you're subject to certain condition or conditions that upon the occurrence or non-occurrence of some event or thing that must take place, you either lose control of the property without remuneration, or you have to abide by that term and condition that you accepted the property under. So if I sell my house with the requirement that it must be painted safety orange and a reversion clause called a reverter interest, or reversionary interest, then you change the color, then if my heirs spot the difference, they can claim ownership rights of that property without charge and regain control of that property because that owner violated the terms and conditions under which they purchased the property. Does this happen often? No. But there are fee determinable interests granted that people sometimes don't realize occur. If you buy a condominium type of ownership property, there are rules and regulations that you must follow, or else they're going to fine you. And if you don't pay your fines, have the right to auction your property off without cost and satisfy their debts, and you lose control of the property. Wow, that's a fee determinable interest. So understand, guys, you have to understand the types of deeds and their interest being conveyed in those deeds to buyers when buying property. So one of the things I would always ask the seller is, what kind of ownership do you have? Is it conditional or is it fee simple? If it's conditional, it would be fee determinable. Now, I said with a reversionary interest, meaning if you do something that is contrary to the condition under which you bought it, then that interest of ownership reverts back to me or my estate without charge. And if you object, my lawyers will sue you and force you to turn the property over free of charge. So I have a reversionary interest in that property if the conditions under which you bought it are violated. So a reverter clause, reversionary interest, would be included in the condition under which you buy the property. Or I could put in what is known as a remainder man clause, meaning instead of coming back to me or my estate heirs, it goes to a neutral third party who then controls the property. So let's take an example. Richard Marin. I sell you my property with the condition that you must remain celibate your entire life. And you buy the property, and then you go out and you have a big party and things happen, and oops, all of a sudden, you didn't keep your vow. And you violated the condition of ownership. Well, if that were to occur and we would find out about it, then your property automatically reverts back to me or my estate or heirs of my estate. Or it's named as a remainderment interest to, let's say it's Gwen. She gets the property as a remainderment, a third party. Wow, you can do this? Yes, you can. Very bad idea to put conditions of ownership on property. By any means, I think you should have as little requirements and conditions of ownership that you can convey. The more conditions that you put on a property's conveyance, the less marketable it is, and values tend to sink when things become less marketable. So understand, guys, you want to make sure that property is fee simple, so you have no problems with condition of ownership. But if there are, then those conditions must be explained to the buyer so that they have full knowledge of what they're buying. So before I move on to life estate, does anybody have any questions about what fee simple or fee determinable mean? Is there a time limit on the fee determinable contract if not stated in the contract? There could be if you want to put one in. Yes, you could, but you don't have to. Is there 55 and up community reversionary? What? Oh, reversionary interest or a fee simple? I don't know. I don't have the deed in my hand. I would have to see the deed to understand it. Are conditions under written are conditions underwritten? They would have to be in the deed. I don't know about written contracts or anything, but I'm not sure exactly what you're asking. Do fee determinable conditions expire? They could. Again, you could put a time frame on them. I don't know what SP period basically mean. Can the condition in which it is in the deed be determined? Can the condition in which the deed be determined voided due to city zoning changes? Example, the code changes now not allow bright colors. No. Because when we talk about zoning, it's a pre-existing nonconformity. It doesn't have to abide by the new zoning codes that occurred after the condition was granted. All right. I sold the house. The new buyers would have to make you keep it looking. If I sold the house, new buyers would have to follow those conditions as well. If that's correct, yes. This would be like the historic towns that make you keep it looking historic. Yes, yes, Ramneet. That's a fee determinable ownership interest. Those historic properties, we're going to talk about that later. So basically, I lose my money. Yes, yes. As the purchaser, yes, you would. Old houses in a town that cannot be painted or changed, for example, are fee determinable. Yes. If it goes to the remainderment, there are no conditions so that they can do whatever they want, correct? I'm sorry, let me understand that. If it goes to the remainderment, the third party, there are no conditions and they can do whatever. No, they're still subject to the deed of conveyance ownership rights. Is there a key difference we should always remember when deciphering the two? One's conditional, one's not. It's hard typing on the keyboards. Yeah, I know. I have that problem too. That's like Cape May houses. Yes, Luciana, exactly. Those are all fee determinable. They must be kept in a historic period, painted certain colors. You can't change them, et cetera, et cetera. Yes. Who's responsible for communicating the terms, conditions to the buyer? The deed. The seller is required to explain those things when conveying deed. And it must be in writing. All deeds must be in writing. Is fee determinable to bamboozle buyers? I don't see why. So if the contract says you can't change the color of the house, does that include additions to the home? New shutters, for example, or new shingles? Does that include new additions? Well, the new addition, whatever you put onto the house, must be the same color as the house, I would assume. Is there a way to have the deed revised to remove the condition? Good question, Elise. Hang on a second, I will answer that. Since there is no other questions, then let's answer that. Yes. However, you're going to have to hire an attorney and go to court and plead your case with a judge. If he agrees, then you can change the condition. But if he doesn't, then you just wasted a whole bunch of money with an attorney and you didn't get a change. So it's up to the courts to determine if they want to change it or not. Most judges are very suspect of changing conditions of ownership unless the owner can prove a specific hardship or some other negative that supersedes the condition under which they purchased it. In other words, you read the deed of conveyance, you understood the terms and conditions in which you bought the house, yet now you want to change those conditions? No, probably not. But in rare cases, they may agree with you and change the condition. Just a rare case. So there's no other questions I saw from what the difference is between fee simple and fee determinable, so let's move on. The third type of estate in real property or freehold estate is a life estate. Now, I'm going to try to use this as simply as possible. I'm going to even use a whiteboard. So here I am, T. I own this property. And I hear that, let's see, who's here? Cynthia has a problem and needs temporary housing for a while. So I tell this to Cynthia. I'm going to grant Cynthia a life estate of my property. Meaning, she doesn't pay me anything. The only thing I'm going to require her to do is pay the taxes and keep the house in good condition and do maintenance. Make sure that the taxes are paid and maintain the property. Don't approve it, but you can maintain it. And she has the right of ownership of that property as long as Cynthia lives. But the day that Cynthia dies, the property reverts back to my estate under a reversionary interest, reverter clause, so that I can now maintain control of that property and do whatever I want with it in the future. So in other words, I granted my estate to Cynthia for a life interest, her life. As long as she's alive, she can use the house, live there, do whatever she wants, pay the taxes and maintain it, and it's hers. But the moment Cynthia passes away, her interest reverts back to my estate. And now I have the right to do whatever I want with my property all over again. So that would be reversionary interest. The same could happen. She could say, you know, or I could say, I'm granting a life estate to Cynthia based on her life. But upon her death, it now goes to Dale. Dale gets the estate. He's the remainder man, third party, unassociated with the deal, that gets the property. If it doesn't revert back to me, it would go to a remainder man interest. Wow. So in other words, it's limited to the life of the specific person. In this case, it was Cynthia. There was a reversionary interest that when she dies, it comes back to my estate or heirs. Or it could go to a remainder man, a third party. So the life estate can be tied to the life of a third party, por otra vie. Now, wait a minute, I just confused you, so hang on. So I could grant Cynthia my estate based on the life of Trinidad. But the day Trinidad dies, Cynthia's got to vacate the property, her interest ends. That's a third party life whose estate interest Cynthia's rights of ownership are dependent on. So if I convey my estate to Cynthia based on Trinidad's life, it's a life estate por otra vie. And I don't speak it, but I think that's French for based on the life of another. So it's a third-party life that Cynthia's interest is based on. So she's very vested in Trinidad's life. As long as he's alive, she gets to live in that estate. But the day Trinidad dies, that estate reverts back to me or to another third-party disinterested remainder man. The holder of the life estate has true ownership of the property, but is limited because it's a life estate. They could sell, lease their life estate interest, but they cannot sell or lease the real property. They have the right to mortgage their ownership interest, but they don't have the right to mortgage the property. In other words, who's going to give them a mortgage based on their life? Not many lenders will do that. It has to be backed up by collateral or real estate, and you can't do that under a life estate. So let's say Cynthia's living there and she says, you know what, this is a dull, boring place. So she calls Elise, and Elise says, hey, do you want, and she says, hey, Elise, you want to live in the estate? I'm moving out. She could sell or lease her interest to Elise to use the estate as hers. Cynthia could collect rent the entire time. I don't get any pennies from it. But the moment Cynthia dies, Elise has to vacate as the tenant, and then I would regain the interest of the property. And an estate interest under a life estate always ends when the person whose life the estate is based on terminates. So a life estate is a conveyance of ownership interest to another person based on their life. If they die, the estate reverts back to me or goes to remainderment. Or a life estate can be granted to an occupant based on a third party's life, pour autre vie. And upon the death of that third party, then that first party has to vacate the property, their ownership interest ends. Did anyone have any question about a life estate? And would anybody ever use this? How old does the third party holder of a life estate have to be? Could be a child, could be a newborn. Are all life estates basically fee determinable? No, they're not fee determinable. How does a property become a life estate? By granting it. How about when the grantor dies? Then his heirs still have the ownership rights to the property when the tenant dies. Is this like the royals giving castles to their friends? I don't know how they do that. That's a completely different system over there in England. I wouldn't even speculate. The royals. What's the main difference between the fee simple and life? If life can go, I'm sorry, let me just try to understand. What's the main difference between fee simple and, I guess you're saying life estate? If the life estate can go to a remainderment. Fee simple is complete control and ownership rights of property, enjoying full rights of ownership. Life estate is a limited interest ownership interest in property. So any home I own can be deemed a life estate if granted. If you want to do that, Dale, you have the right to give out life estates if you're the owner. Is there having a remainderment important to the owner? Doesn't have to be. So this is an example of an estate being passed down by generations of a family. Not that I'm aware of. Okay, the DuPonts owned tons of property. I suspect they had homes deemed a life estate. That's possible. This is for a property that is owned outright by owner, no bank liens. Yeah, pretty much. If you're in your example, what if you have no remainderment or heir and you pass? What happens to the life estate occupant? Well, Brian, I wouldn't grant the life estate unless I had a remainderment or a reversionary interest named. Basically, when Cynthia dies, it goes back to the owner unless he has, yes. Are life estates subject to inheritance taxes? For which party? Can an apartment be a part of a life estate? If it's on the property being granted, sure. So we can rent a life estate property but can't sell it. Correct. And the tenant's interest dies the moment the life estate grantee dies. Samanda, I did answer that. The tenant would pay the taxes. After the estate goes to remainderment, it is now a fee simple property. Could be or may not be. What's the conditions of the deed that are stated? So there's no generalities here, guys. Everything is case specific and has to be studied to find out what happens. There's no overall general, oh, that happens in a life. No. It's whatever the deeds state. All right, I'm going to moderate here for a minute. So, good questions, by the way. All very good questions. Hang on, Sergio pasted a paragraph. The owner of a normal life estate does not have the right to pass ownership to heirs because the life estate ends with the death of the owner. Is that referring to the owner of a normal life estate? That's the person who's the tenant. They own a life estate interest in the property. That's not the owner of the property. So now let me get back to what I forgot what I was going to say. Okay, fee simple, fee determinable, a conditional interest in real property. Life estate, more or less a temporary interest in property based on your life or the life of someone else, with a reversionary interest that goes back to the owner or heirs or a remainderment third party. Who would use a life estate? Well, interesting you ask. Thanks for asking, by the way. Several years ago, I was an elected official in my town for 2 terms. I was a councilman. I don't like politics, but I did my civil duty, and then I decided not to run for a 3rd term. But anyway, while I was a councilman, we approached a couple property owners about potentially buying their ground, their lots, so we could build a senior care facility for low and moderate income seniors. We had the spot picked out. It was near the first aid squad and right next to the senior center. And the 2 property owners were very understanding. And one property owner said, yeah, I'll sell you to it right now. And we agreed on price, terms, and conditions. The second property owner said this, yes, I would do that. However, a month later, he came to the council meeting and said, after discussing with his wife and family members, he had decided that he was going to dedicate his property to the town of Oakland without having to pay a nickel. That would be huge to us because we could save several $100,000 in acquisition cost. But he said there's a condition I'm going to attach to the property, and that is that my aunt so-and-so be granted a life estate until she dies. And the town would be named as the remainder man, so that from this day forward, Aunt so-and-so is going to live on the property, and upon her death, the town gets the property. Now, that was about 10 years ago, and she was about 90 years old at the time. So we were figuring, any minute now, this auntie is going to pass, and we're going to get the property. Well, about a week or so ago, remember we had that big rainstorm and snowstorm and winds and everything? She was out cleaning up branches and things on the property. Here's this gal who's 100 years old, and she's out in the cold weather, rain and snow and storm, cleaning up branches that fell on the property. She's like a battle axe that won't die. But the day that she does, the property comes to the town of Oakland as a dedication because we're named as a remainder man from a life estate interest that now has expired. That's a situation where a life estate is used for the benefit of all parties involved. Very well documented and well constructed way to convey property. So there are reasons why people would do life estates. I've never been involved in one. I won't even speculate as to why people would want to do it, except maybe to protect their family generational homes or things like that. But again, these are situations where everybody, as a realtor, has to ask questions to find out what type of ownership is being conveyed. So, if there's no other questions, are there? Maybe one or two. Maybe we should just go back a page until we're done with our questions. Yeah, right? Don't never give in, Patrick, right? Never give in. Yes, yes, David, we did say we can lease out life estate interests. But again, that tenant, when they die, the life estate interest dies. That means that tenant they rented to has to vacate the property. No, she's still kicking, Deborah. She's a battle axe. She's never going to die. Was there any other questions before we move on? What happens if life tenants, what happens to the buyer of that life? What happens if life tenants sell? In other words, they sell their life estate to someone else. Well, those people then would move in the property as if it's a loan. However, when that person whose life the estate was based on dies, they have to immediately move out. So they spend a lot of money for no reason at all. What's the advantage of letting the ant live there? It has nothing to do with the concept of what we're talking about. So please, let's just try to keep focused on the concepts being presented, not on the what ifs and the permutations and how does that affect me and all. No, just remember this is a life estate, that's all. All right, I'm going to move on, guys, unless there's another question. What are the pros of a life estate? All right, one more time. It offers a living situation to someone who may not otherwise be able to afford it. I grant a life estate to you, Arson. You don't have to pay mortgage. All you have to do is pay the taxes and maintain the property. So you're going to live with only having to pay taxes and maintain the property. You have to pay mortgage or anything else or rent. And you can live there as long as you want. And if you don't want to live there, you can sell your interest to someone to make money. You can lease your interest to someone else and make money. But as soon as you die, the person you sold your interest to or leased it to has to vacate the property because their interest ends when you die. So there are pros, several of them I just stated. All right, let's move on. Dower and courtesy rights. What's that? Well, here we go. So I'm going to use a whiteboard real quick. May 28, 1980. That's the date you have to remember. May 28, 1980. Prior to May 28, 1980, there was things called dower and courtesy rights. Dower rights were the female interest. Courtesy rights were the male interest. I'm sorry, I should be more gender neutral, so it's a man and a woman. Oh, did you hear this? This is so ridiculous. Some guy in the Senate or Congress was making a prayer and he ended his sermon with an amen and then an a woman. What a moron. Anyway, so dower and courtesy rights existed prior to May 28, 1980. After May 1980, no new dower and courtesy rights were created. So what are dower and courtesy rights? Okay. First of all, dower is the wife's right to the husband's interest in real or all property, and courtesy is the husband's rights to the wife's ownership of real or personal property. If a couple or a spouse, if spouses were married prior to May 28, 1980 and owned real estate, then upon the death of one spouse, the remaining spouse automatically inherits all personal and all real property that the husband had interest in. Her name or his name, whoever the surviving spouse is, their name does not have to appear on ownership records anywhere. If the other spouse died but had ownership rights of those properties, then the surviving spouse automatically gets all real and personal property interests that the husband had. If the wife died, the husband gets all real and personal property interests that the wife had interest in. And even if his name's not on the documents, he inherits those immediately upon her death. After May 28, 1980, no new dower and courtesy rights were created. Therefore, if you were married and owned property after May 28, 1980, upon the death of one spouse, the surviving spouse does not automatically inherit all the personal and real property of the deceased spouse. In fact, the surviving spouse's only real ownership interest comes in the form of the family home, or the marital residence, they call it. What about all the other properties? They may not have the rights of ownership. Let me give an example. Let's say, well, I told you I live in Oakland, New Jersey. I have a family home, my marital residence, where my wife and I and kids were raised. Let's say I have a home down in LBI, vacation home. I also happen to have one up in the Adirondacks because I like to go up there during the summer and do some backpacking and hiking. And don't tell her, but the little wife doesn't know I got a love shack in Hackensack here. Yoo-hoo, my love shack in Hackensack. Well, her name is on the family residence in Oakland. Her name's not on the property in Franklin, in LBI, nor is her name on the property in the Adirondacks, nor is her name on the love shack in Hackensack. So the day I die, she gets the marital residence in Oakland only because of what's known as rights of possession. She lived there. It's her residence. It's the marital residence of the marriage. She gets the 100% ownership rights of that property upon my death. The Adirondack house, the LBI house, and the love shack, she may never even find out about or have an interest in, because my will specify who gets those things. And if I don't have a will, the state of New Jersey will determine who gets those things. Yeah, you got to get a will to protect your ownership rights of property, guys, personal and real. But here's the lesson. Dower and courtesy rights existed before May 1980. Husband and wife, spouses, who were married prior to that date and owned property, upon the death of one, their surviving spouse gets everything automatically. After May 28, 1980, if you were married and owned property, and one spouse dies, then the surviving spouse only gets the marital residence, if there is one, and any other property her name shows as an ownership interest on. If it's not, then she doesn't own it. Wow. So you mean if I'm successful and I buy a house, and here's now after 1980, and I spent a lot of money for this house, and then I get married, if I die, my wife gets the house automatically? Yes. That's because of rights of possession by law. But I don't want her to get the house. Then you better be seeing an attorney about this, because you probably should have drawn up a prenup or something. That's up to you. I'm not even going to go there. But the fact is, upon the death of one spouse, the surviving spouse automatically gets the marital residence, the family home. Other property, if her name is on it, she gets. If not, she doesn't get. And the state of New Jersey, if there's no will determine who gets. And if you don't like that, tough. That's the way it works. That's why you go to probate court and argue your case before the judge. Any questions before I move on about dower and courtesy rights? I just explained that, Ayana. That's what I just spent the last 10 minutes explaining. What if he states in his will he does not want her to get it? The family, the marital residence, she has every right and cannot be denied that right because of rights of possession. What if you make a will to give the house to the kids? Does the wife still get it? Yes. If you are not married in New Jersey, the surviving partner wouldn't get any property, correct? In New Jersey, Anna, we do not recognize common law. Therefore, there is no palimony or rights of surviving partners, only rights of surviving spouses. Is it only abolished in New Jersey? Is what abolished in New Jersey? So I override his will. In the case of the marital residence, yes. Who does the state usually give the home to if there is no will? Well, they may sell it and keep the money under what's called escheat, or do a law of descent search to find if there's any kids they can give it to. What if the husband dies and was married 2 times? Well, whoever the current wife is gets the house. The first one gets nothing. And you're asking a question that is best directed to an attorney, Jody. I'm not an attorney, and I wouldn't even want to venture into trying to solve that question. What if the non-family home is tenants by entirety? What was that? I'm going to stop here for a second. What if the non-family home is tenants by the entirety, which means her name is on the deed, she gets it. Okay, so the only thing that has changed as of May 20th is that you don't need the spouse's signature and can sell it without the spouse's approval. If it's not the family home, yes. Is a living trust a good consideration rather than a will? That's up to you and an attorney to figure out, Robert. I'm not an attorney and I couldn't answer that question. Can't give legal advice. If you are married, can you leave it to your kids instead of the husband? No, it goes directly to your surviving spouse. What about the kids? They'll get it after the spouse dies. Let's see, was there any other questions? What about common law marriage law? I just said, Lucianne, about 3 minutes ago, there is no common law recognized in New Jersey. No worries. So, Jose Sotomayor, you have been typing for a long time. Do you have a question, or did you forget your dialogue bar was open? What if the living spouse remarries upon her death? Will the new spouse get it? What if the living spouse? So you're the living spouse, you inherit the family residence upon your husband's death. And then you remarry. Then the new spouse, if you die, will get the house, correct? If you don't have a husband, you can leave it to your kids. Sure. That's assuming you make out a will. Without a will, then probate court decides who gets it. The example you used about the 3 properties that were under your name, since her name isn't on them, and if it isn't specified about who the properties go to, do they become intestate? Well, if I have a will, then they are testate. If I don't have a will, then I died intestate, and the courts have to determine who gets the property. The probate courts have to determine that. Oh, Luciana, I can't answer that question. New Jersey does recognize same-sex marriage. So if you're married, you're under law, you're still spouses. Once there is a divorce, it is no longer considered a family home, correct? Yes. What if both sign because it was a family home? Oh, I'm sorry, stop for a second. Let me try to understand what you're asking. Once there is a divorce, it is no longer considered a family home. The one spouse who moves out has no rights once the decree is initialed. And if the decree is satisfied, then the spouse who moved out has no rights to that property. What if both signed what? I'm not sure what you're asking now. What if both signed because it was family home? I don't mean what signed what? I don't understand your question. Gay marriage have the same rights now, guys. Yes, they do. A couple divorces, one dies right away. What? I don't know. Do you need a will with a fee simple estate or automatically goes to your heirs? Do you need a will with a fee simple estate? Or automatic, or, well, yeah, you should. Okay, I'm gonna make a cautionary comment here. Anybody who has anything worth value should have a will. One of the things I find myself doing is every time I sell a house is ask the buyer, do you have a will? And a lot of them say no. Then I'll ask the question, what happens if you die? Who gets your property? Oh, my wife gets everything. How do you know? In other words, like many people here, they had no idea about this dower and courtesy rule. They wouldn't know. In this fact, they could lose control of much of their real estate if they didn't make out a will. So, my friends, it is very important to make out a will to protect your heirs against loss of assets. Very important. Was there any other questions I can answer before I move on? To be more clear, I'm sorry, I skipped something. So before 1980, all properties went to the spouse. After 1980, only the main residence does. Correct, Ashley. To be more clear, if you have a family home, can just spouse sign the deed so that in the case of divorce, it goes only to that spouse? No, I'm not sure what you're asking, though, and I'm not sure if I even answered that correctly. Let me see if I read that again. If you have a family home, can just spouse sign the deed so that in the case of a divorce, it goes only to that? I don't understand the question. I'm sorry, Rachel. My father just passed away and my mind had to go through all of this. Please make a will or it will be a... Yes, thank you, Stephen. Yes. So I don't think any questions asked would be on the test. Probably not. You're absolutely right. We're going into the what ifs here. How this change after 1980 come about because of creditors? I don't know. It was the law that was enacted at the time. So who gets the house if it's a divorce and they both signed the... Well, hang on a second, guys. I think you're mixing a lot of different things together here to make up questions, it seems. So who gets the house if it's a divorce and they both signed the... What do you mean they both signed? If they're both divorced, then only either one was granted ownership of the property, or usually divorce requires the house is sold and the assets split equally between parties. But so I don't understand how both could sign a deed if they're both divorced. If you're divorced, you don't have any ownership rights anymore, according to the divorce decree. So, Yana, I'm not even going to try to answer your question because it's a hypothetical and it's way off tangent here. I just want to keep focused on what dower and courtesy rights are. All these permutations you guys are asking questions about have nothing to do with the test. Please try to stay focused in understanding these concepts as presented and not let your mind start wondering, what if, and what if the case of, and then this and that. No, stop. You're not going to be tested on the 1,000 what ifs. You're going to be tested on what's a dower and courtesy right. So please try to stay focused, guys. I don't want to try to, sound like I'm trying to belittle anybody. I'm just trying to keep you focused on what's important to pass the test. So I'm unfortunately going to have to stop asking questions now. We've got 10 minutes left. I still got a chapter and a half to get through, and I don't know if we're going to, if I keep doing these questions, we're going to get so sidetracked, we're not going to get this stuff done. So again, I don't want to sound discourteous, but I can't be answering all these what if and permutation of certain things and different variables interjected. Guys, don't do that. Stop thinking like a citizen. Start thinking like a real estate agent. I have to know this concept and that's what it means, period. So please understand, we have to get through this stuff. And the best way to do that is to pre-read your chapters, understand what's being discussed, ask simple questions about the meanings of things, not the what ifs and the wherewithals and the one and twos and all that. Totally out of line. Let's try to keep focused. So I got to move on. So now that we talked about dower and courtesy rights, let's talk about encumbrances. Now, I've only got 10 minutes to start this. So I'm going to try to get as far as I can in the 10 minutes we got. First of all, an encumbrance on property could be financial. It could be physical in nature. What do you mean? A mortgage is a financial claim, or they term it a lien on real property. In other words, I have no complete control of my property. It's subject to me paying that financial encumbrance, the lien. When I pay that lien off, the bank has no business telling me what I can and cannot do with my property anymore. I can do whatever I want, subject to the public laws that exist. So an encumbrance is something that comes against the property, whether it's financial or physical in nature. Liens are financial claims against property. Mortgage claims are mortgage financial liens. Unpaid property taxes are financial liens on property. Unpaid special assessments or improvement taxes are unpaid financial liens against property, and therefore encumber the property with that lien, and the lien must be satisfied in order for the encumbrance to be removed. So an encumbrance is something that comes against the property, whether it be physical or financial in nature. Liens, financial claims against property, are financial in nature. They're a lien. A usage restriction, like a deed restriction or a encroachment, something your neighbor built a building on the property line that went across the property line by 3 feet. That encumbers your land, and he's got a physical encumbrance now coming across the property line onto your property. It encumbers your property with this physical intrusion. You have to remove that in order to sell the property as required. So encumbrances come against the property and prevent the clear transfer of ownership interest in a fee simple nature. So liens, let's talk about liens first. A lien, as I said, is a financial claim or interest in real property. And the property usually is used as security or collateral for the debt incurred. Your mortgage, your property taxes go against the property. So a voluntary lien is created by the owner. A mortgage, that means he voluntarily borrowed money from a bank and paid for the property with that money. He has to pay the bank back. So the mortgage is the lien, financial interest in the property until it's paid off. It's a voluntary lien. The owner chose to do that. If he could, he would pay cash and there would be no lien. So therefore, it's a voluntary lien, a mortgage. However, your property taxes, those are involuntary liens. Property taxes are a lien against your property until they're paid. If you don't pay those taxes, then that lien is enacted against you, and you may lose control of your property because you didn't pay the lien. That's an involuntary lien, property taxes. General liens go against all your property. Specific liens go against one specific property. Let me explain. Your property taxes are a specific lien. Goes against one parcel of real estate. You have to pay those taxes, and if you do, there's no problems. But if you don't, you may lose control of your property. That's a specific lien, goes against one property. A general lien, an example of a general lien may be an IRS tax lien. Ooh, you didn't pay your income tax for a few years, and the IRS got fed up with you, so they put a general lien against all your property, personal and real. And if you've ever talked to anybody who's had a general lien against them, it's everything they have. Their house, their car, their motorcycle, their boat, their ATV, their clothes, their jewelry, their bank accounts are seized by the IRS as a general lien against all their property. But a specific lien only goes against one piece or one specific piece of property. So before I move on, did anybody have any questions about what a lien is? Robert Weiss and Rachel Burke, you have questions, so I'll wait for your questions. Well, you can do whatever you want with your property, Robert. I wouldn't advise you to do anything like that, but you can do whatever you want. So would a specific lien be like a car seizing? Specify what you mean by what's a car seizing, Madison. If you lose your property because of a tax lien, does that next buyer of the property have to satisfy the tax lien? We're going to talk about this tomorrow morning. So hold your question off about tax liens. We're going to go there tomorrow morning. If I was informed, if you invest in tax liens, you can pay off liens if the owner does not pay you back within 2 years, because again, we're going to talk about the tomorrow, Ayana, under the taxes. So hold off on your question till tomorrow. Like taking a car, the bank taking a car. Oh, you didn't pay your car loan. So that car loan would be a specific lien against that one piece of personal property. Yes, correct. I'm sorry, I didn't understand your question. So the voluntary lien is optional to protect yourself. If you want to, yeah. Can you give more examples of physical or usage? We will when we get to them, Sergio. Right now, we're just talking about financial liens. If your family house is in the name of a spouse, can there be a lien against your house if spouse, I'm sorry, whoa, hang on a second. If your family house, your marital residence, is in the name of spouse A, okay, can there be a lien against your house if spouse B, what? Has a lien against them? Well, first of all, Michael, let me try to understand what your question is asking. If your family house, which has ownership interest both by husband and wife, can there be a lien against your house of spouse B? What are you, a polygamist? You got 2 wives? That's illegal in New Jersey. You can't do that unless I'm misunderstanding your question. So maybe you want to retype that question in a format maybe I can understand better. Well, if you've been married twice, that means, first of all, you had a divorce from the first person, which has no further interest in property because they're divorced. There's no need to shout, David. Like I was married before my house is in B, both our names. Well, not anymore since you're divorced. They mean if the husband has a lien. Well, because it's owned by both, then both are responsible. I'm guessing that's the meaning of your question. If my house is in my wife's name and I have a lien against me, can they put a lien on the house if I don't have my name on it? Well, if you say you have a pre-existing tax lien, that's a specific lien against the property, Molly, right? If that's what he's meaning, then I would agree with your statement. However, I'm not sure if that's what Michael means. I have a lien against me. So it's a personal claim against you, or is it backed up by the real estate? I'm not understanding the question. And only my part would go to, okay, I guess we're losing it here. I know it's 12. I'm just trying to figure out these questions, but this may be a moot point. So again, let's do this. Let's not steer off course, guys. Just understand what a lien is. That's what you got to understand. So I'm going to be going on break now. It's 12 o'clock. In a minute or two, Lauren or Noel, we're going to be coming on here to answer your admin questions. At 1 o'clock, I'll rejoin you. Please, if you have questions, don't venture away and come back in 15, 20 minutes and start asking questions again, because chances are they've been answered 2 or 3 times. So I'll see you guys at 1. And in the next minute or two, Lauren or Noel will come on and answer your admin questions. See you at 1.